South Carolina homeowners are in the second year of a legal fight with a new Indy paper mill in York County. Those homeowners' lawyers today argue they want to have a say in another legal battle between the mill owners and environmental regulators. South Carolina Bureau Chief, Shakira Speaks, is here with the details of today's hearing.
Yeah, Brian, the EPA's Clean Air Act emergency order against the new Indy containerboard plant outlined evidence that the mill's operations, quote, are emitting hydrogen sulfide into the air, unquote. It also states that owners were allowed to continue the same operations. They would present, quote, an imminent and substantial endangerment to public health and the environment. Attorneys for the class action lawsuit against New Indy claim that's not enough from the EPA to keep them safe.
The essential question before the court is whether the victims of New Indy's violations of the Clean Air Act should have a right to intervene in an enforcement action brought by EPA for the very purpose of protecting their health.
Attorneys representing neighbors in one of the class action lawsuits against New Indy Containerboard argued their case in front of appeals court judges Thursday morning. They claimed despite the issued Clean Air Act emergency order and New Indy's acceptance of the order, plant operators have continually violated the agreement. And now neighbors want to intervene on their own behalf.
They should be able to intervene, and federal law expressly authorizes them to do so.
Homeowners lawyers say the EPA disagrees on whether New Indy met the standards for intervention under the law. Attorneys argue if plaintiffs meet that standard, then they have the right to intervene. Several parts of the Clean Air Act grant citizens the right to bring a claim against anyone they believe is violating the act.
It was therefore entirely appropriate for the interveners to seek to intervene, to join in that action, particularly when they became concerned that EPA was allowing the mill to get away with a prolonged delay in implementing and coming into compliance with the terms of the order.
EPA lawyers argue New Indy followed the 2021 agreement that the plant was not permitted to exceed a certain level of emissions. They argue the district court judge who ruled on the case got it right.
Congress said that citizen plaintiffs could sue for violations of standards, limitations, and orders, except when the United States is bringing a suit already for a violation of the same standard, or limitation, or order with respect to such.
So the EPA's attorneys argue that because the original order expired, the intervention suit isn't applicable here. Regulators say if homeowners want to sue, they can, but not under this order. And that's why they agree with the district court judge who rejected the initial motion to intervene. Right now, there's no date for when the appeals court judges will issue their ruling. Guys, back.